Hey guys, I'm back and we have Wayfarer's opposition to Lively's motion to seal. When I say Lively's motion to seal, really nearly all of this is about Ryan Reynolds, and Alexandra Shapiro does not disappoint at all. It is brutal for Reynolds, amusing for me. So let's go. Dear Judge Lyman, the Wayfarer parties write in response to Lively's motion for sealing. Lively carries a heavy burden in seeking to seal summary judgment and sanctions materials. The Second Circuit instructs it is not and should not be an easy matter to deny the public access to documents that are utilized in judicial proceedings and form part of the basis for judicial decision making. That is because public monitoring is an essential feature of democratic control. Monitoring both provides judges with critical views of their work and deters arbitrary judicial behaviour. I feel like this is a dig at Lyman. Without monitoring, moreover, the public would have no confidence in the conscientiousness, reasonableness, or honesty of judicial proceedings. Yeah, I really feel like this is a massive dig at Judge Lyman. If you seal all her stuff, you're not basically allowing the public oversight into your work. The majority of Lively's requests fail to overcome the strong presumption of public access at this stage. Crucially, Lively cannot hide key facts of this litigation from public scrutiny simply because she finds them embarrassing or unhelpful to her case. As detailed in an accompanying chart that will be separately submitted to the court, the Wayfarer parties agree that certain financial information concerning the film and non-parties, as well as information that could implicate Hoover's privacy, should be sealed. Separately, the Wayfarer parties do not object to sealing references to true non-parties such as actors who were considered but not chosen to appear in the film, and other Jonesworks clients. The Wayfarer parties also take no position on the sealing of one witness's medical information, although such information should be disclosed if the matter proceeds to trial, as it bears on the witness's credibility and knowledge. But Lively's sealing requests go well beyond these narrowly limited and well-established exceptions to the public's presumptive right of access. Lively seeks to hide from public view the identity of key witnesses, people she herself involved in this dispute because of who they were. Famous, powerful Hollywood players who uniquely commanded enough influence to convince Sony to take a film away from its director, Baldoni, and to try to destroy his career. Oh, I wonder who that could be. Sean Levy, Hugh Jackman, Bradley Cooper, Ryan Reynolds. Chief among these claimed non-parties is Lively's husband, Ryan Reynolds, the subject of her sealing request in Wayfarer's motion for summary judgment exhibits and Wayfarer's spoliation opposition exhibits. Reynolds is not an innocent third party by any stretch of the imagination. He is the proponent of the Rule 11 sanctions motion at issue here. Yet he has asked the court to seal nearly all of the documents submitted with the Wayfarer party's supplemental opposition to that motion. In seeking to protect her husband, Lively relies on Deseroladora La Ribera, but that case is entirely inapposite. There, the court redacted the identity of a potential customer who was not affiliated with any party and not accused of any wrongdoing. From the outset, Reynolds involved himself in the production of the film and Lively's objections to it. He secretly rewrote the film's pivotal rooftop scene under Lively's name. He berated Baldoni for supposedly commenting on his wife's weight before shooting began, which is a subject of her claims. He participated as Lively's designated representative in the all-hands meeting to discuss Lively's objections months later. The very documents Lively now seeks to seal make plain that Reynolds continued to deliberately insert himself into this dispute, redacted, long before the Wayfarer Party's alleged smear campaign supposedly began. After the premiere, these messages show that, redacted. In at least one instance, it appears that, redacted. Lively has asserted marital privilege over her communications with Reynolds, but it is fair to infer that Reynolds' communications to third parties were made with her consent, based on the information she provided, and on her behalf. And although Reynolds was not deposed, there is no dispute that he is a key witness who may well be called if this case proceeds to trial. Both parties named Reynolds on their initial disclosures. Oh, okay, so we have a footnote. Where does that come from? Oh, it's up here somewhere, footnote 1. So redacted is an alias for Reynolds in this document. The Wayfarer parties have no objection to replacing the alias name with Reynolds' name. Oh, interesting. Lively offers no basis for sealing Reynolds' communications beyond her fatuous claim that he is not really involved in this case. The information at issue does not disclose anything private or especially sensitive. And then we have another footnote. Lively asserts that Wayfarer's motion for summary judgment, the two exhibits 205 and 211, reflect private information about her family. Lively has not identified such references, and none are apparent from the review of the text. Rather, Reynolds primarily discusses redacted, a subject that has no bearing on his own privacy concerns. Lively also seeks to hide the identity of the famous people she recruited as advocates on her behalf against the Wayfarer parties in her attempt to take over the film. We have a footnote again. In Wayfarer's motion for summary judgment, Exhibit 95, Lively recounts a conversation about the appearance of a famous person. There is no basis whatsoever to seal this reference, and I can't wait to read it. But information ought not to be sealed or redacted solely because it may harm a party's public reputation or celebrity status. Witness identities are shielded from the public only in rare circumstances, such as where there is a danger of impairing law enforcement or some credible safety risk. There is nothing comparable here. Moreover, not only are these individuals key witnesses in the case, but their identities are essential to enabling the public to understand the Wayfarer party's defence. Lively did not merely vent her frustration to friends. She sought out people with immense influence in the industry, and she explicitly weaponized that influence against the Wayfarer parties. Oh. Recruiting, redacted. Stating, redacted. Lively's PGA letter invoking, redacted. Moreover, Lively had no qualms about publicly divulging the identity of other famous people in whom she apparently confided, identifying inter alia Emily Blunt, Alexis Bledel, America Ferrer, Gigi Hadid, Hugh Jackman, Taylor Swift, and Amber Tamblyn. It is only now that the messages place Lively and her friends in a negative light that she seeks to hide their identity. Lively should not be permitted to use sealing tactics as a sword and shield in this manner. As this court has acknowledged, a generalized concern of adverse publicity is not a sufficiently compelling reason to outweigh the presumption of access. That is particularly so at this stage of the process when, As this court has rightly stated, the presumption of public access is at its peak. Lively also seeks to seal the identity of other witnesses. First, she seeks to seal the identity of a crew member who discussed filming with the film's intimacy coordinator. Lively identifies no privacy interest whatsoever concerning the crew member, and none is apparent from his communications. Next, Lively seeks to seal references to Lively's personnel staff, even though their names were already made public by Lively herself when she identified those individuals in her initial disclosures and stated no objection when the disclosures were filed on the public docket weeks ago. She has also cited them as witnesses supporting her case. Although Lively claims some of these individuals suffered harassment when their names were initially disclosed, she offers nothing to suggest that disclosing the additional information at issue here would cause any further harm. Finally, Lively seeks to seal information about her compensation for the film. That information has already been publicly disclosed without objection, and it's directly relevant to the independent contractor issue raised on summary judgment and to Lively's damages claims. Lively also claims those documents should be sealed because they divulge WME's commission rate, but WME itself does not and cannot claim that information is competitively sensitive because it is the industry standard. For the foregoing reasons, the bulk of Lively's sealing request should be rejected. Well, that's wounding for Lively. I look forward to seeing how this one pans out. I have a feeling, though, that I can't see how Judge Lyman is going to get around this. I think the way Shapiro has written it really puts him in a corner, especially with that. If I go back to it, because I absolutely love this. But, especially this top paragraph here, where, there is so much made well, if you keep sealing these documents, you are not, and deny public access to the documents, then you are denying public, access to the judicial decision making, specifically Lyman's judicial decision making. And, if you do that, it's going to affect confidence. I think she's put him in a bind with that. So we'll see how that goes. I think I'm going to do Sony's next, and then tomorrow I'll leave it until tomorrow now because it's midnight here nearly. To do Family Hive and Betty Buzz. There's nothing overly interested in them. I mean, they're worth looking at anyway, but there's nothing exciting as there are in these ones.